Chapter 3, Risk Management in our Broker Transition course. The purpose of risk management is to protect, preserve, and promote the growth of the brokerage company, which ultimately results in consumer protection. Fair housing laws, we'll start with those as a way of protecting consumers and also protecting ourselves. The Federal Fair Housing Acts. The purpose is to create a marketplace in which all persons of similar financial means are shown the same range of homes and location of their choice. And that's a big word, choice. In that whole paragraph, that's the key word to fair housing. A free choice for people in their pursuit of housing. Failure to comply with fair housing laws is both a civil and criminal violation and constitutes grounds for disciplinary action against the licensee. Remember, fair housing laws can include federal fair housing laws, state fair housing laws, county fair housing laws, city fair housing laws, and there are even township federal fair housing acts. Okay. The fine for the first offense for a violation of a federal fair housing act is $16,000. Fair housing laws investigation. This is I've got this on page 41, but I want you to know this is not really in the book, that HUD has just provided $28 million in grants to investigate and to promote fair housing opportunities. In Illinois, those $28 million went to these agencies and these stakeholders. They went to the Oak Park Regional Housing Center, John Marshall Law School, Interfaith City Center of Northern Suburbs, South Suburban Housing Center, and Hope Fair Housing Center. You can see the monies that these Illinois recipients have. So what that means is somebody's going to continue to do investigation, because that's primarily what they do with that money, in addition to promoting fair housing through educational opportunities and outreach programs. What they do is they use this money to investigate potential or allegations of violations of fair housing. So you want to know about it because you could be somebody on their your company, and you could be somebody on their investigation list, which we don't want. So if we learn all this stuff that I'm talking about in this chapter, you'll be just fine. By the way, false entrapment is no defense. When testers come in and test on the way you handle people as it relates to fair housing issues, the fact that they're lying to you or making things up or pretending to be somebody or not, or even engaging in contracts under the false pretense that they're actually sincere sellers or buyers or landlords or tenants, usually buyers and tenants, the fact that they're quote entrapping you is no defense. The Supreme Court has held that false entrapment does not apply to these fair housing testers, that the mission of fair housing is one that is great enough that will tolerate quote false entrapment. Fair Housing Act prohibits discrimination on the basis of race, color, religion, sex, disability, familial status, and national origin. The Fair Housing Acts are administered by HUD, the Department of Housing and Urban Development. And it requires that posters, look on page 45, be displayed in any place of business where real estate is offered for sale or real estate. So your office, whether it's a commercial office or whether it's a residential office, I would put that poster you find on page 45 up. The Fair Housing Act applies to sellers as well as to their agents. Agent age, by the way, is not protected currently under the federal statutes. It is, however, under the Illinois statutes. And that equal opportunity in housing logo that just popped up there, you should be using that whether you're a commercial organization or a residential organization, property management, or if you're involved in brokerage. You should be using that fair housing on all of your contracts, on all your business cards, on all your forms. Certainly make it part of your policy procedure manual. If you are ever investigated on allegations of fair housing violations, they're going to want to see if that poster is somewhere in your office, and they're going to see if you are using this sign liberally. If you're not, it sort of implies that you don't really believe in fair housing, so use those. Fair housing exemptions, yes, there is possible for people to discriminate to various protected classes and not be guilty of fair housing violations. But these are very, very narrow exemptions. The first is if you're an individual and you own a single family house and you're renting it by selling it or you're renting it, and if you're not using a real estate agent and you're not advertising, technically you can sell it to whoever you want to, except as it pertains to race. Race is always a protected class. There are no exemptions to fair housing discriminatory practices as it relates to racial discrimination. For instance, a dwelling which is owned or operated by a religious organization could in fact exclude people who aren't members of the religious organization. A lodging owned and operated by a private club for their members, if you will, private club members, could disallow non-members, housing. Housing intended for older persons could eliminate individuals with children. Now, as you can see, the sign there says must qualify. Housing for older persons only qualifies if everybody in that housing area, that apartment complex or that development area, the condo complex, is 62 or over, or 80% of them are 55 or older. So it just isn't one of these deals where you put a sign out that says this is a senior citizens place, kids stay out. You must actually qualify for it. The Civil Rights Act of 1866 is where Jones versus Mayer. Jones was an individual who felt he was discriminated against as an African American. He sued Mayer Company. They were an Ohio real estate firm back in 1866. The Supreme went to the Supreme Court. The Supreme Court said that all citizens of the United States, regardless of their race, are entitled to equal access to real estate. So that's where our first Civil Rights Act came from, 1866, and that's why race today, because the Supreme Court said so, is always the protected class. Some other practices that we need to be a little wary of. Blockbusting is an illegal practice whereby a broker might go into an area along a color line. So you've got the red people living on one side and you've got the blue people on the other, and you go into the blue neighborhood and you say, hey, you better sell today. The red people are knocking on the door over here. Before you know it, they're going to be living on this block, and your property values are going to decay immediately. So sell today. You'll get the highest price today than if you wait till the block is busted. And of course, when the block is busted, because a red person would then buy in the blue area, then you use that as a way of negotiating listings for all the other owners of the block. Blockbusting then is this way that you peddle panic and tell people to sell today because their block is going to be busted, and you're going to create alarm in the area that their properties will then decay in value. Steering is where you channel people to areas you think they would be most comfortable in. You steer people or channel them into racial areas that match their racial profile. So the Asian Americans go into one area, African Americans in another area, the Hispanic Americans go into another area, and of course you're doing that because you think they're going to be more comfortable there. You always let the customer set the limits. Let them set the choices of where they want to be. You don't decide where they want to be. You let them decide. If not, that's steering. Redlining is what lenders do when they discriminate where they will lend money based on where the property is located. The name comes from where a loan officer would meet with other loan officers, and they would draw a line through their town, a red line, and say, if anybody wants to buy properties in that area of the town, on that side of the red line, we won't lend any money. And of course that's where all these properties would become blighted because no one could buy them, and therefore they would sit idle and vacant and decaying. Redlining is a discriminatory practice. The only time you can refuse someone as far as a loan isn't based on where the location of the property, and it's not located based on any of their protected classes, their race, their color, or religion, national origin. The only time you can deny someone a loan is based on their credit worthiness. If they do not have the credit ability to, whether by income or by the other standards that you've set up as far as years of employment, etc., then you can deny a loan. Advertisements with language indicating preference or limitation. Be careful when you're advertising property that you're not subtly, trying to steer people to or away from the area. Enforcement of the Housing Act. The Housing Act is enforced by HUD, and it starts with a complaint filed to HUD. Usually you have 100 days from the time of the occurrence where someone can file a complaint against you. There's an investigation, and they either decide after the investigation to let it go, or they go to the next step, which is a formal hearing. If at the end of the formal hearing they find there has been some fair housing discriminatory practices, there can be some damages levied. These can be civil, these can be criminal damages, there can be civil action, and there can be fines and penalties, and your license can be disciplined. Errors and omission insurance coverage, while that is a good idea, typically does not cover violations for fair housing laws. So errors and omissions isn't going to pay your legal fees or any fines that you've received as a result of this. Illinois has its own Civil Rights Act. It's called the Illinois Human Rights Act. It covers not only the same classifications that the federal act does, but it also covers additional protected classes. So page 51 talks more about the Illinois Human Rights Act and the additional ones that it covers. If you violate the Illinois Human Rights Act, the Illinois Department of Financial and Professional Regulation can discipline your license. It also protects against people with children, which is called familial status, blind and hearing impaired, physically disabled, and use of a service animal. And while we're on it, a service animal is not considered a pet. So if you have a prohibition against pets in your apartment complex and someone who has a service animal wants to rent there, you can't discriminate against them because of the service animal. Page 53 has a very important topic at the top where they talk about Fair Housing Compliance Program. And this is something we're going to spend just a little bit of time with because I think it's going to be very, very helpful to you. The last thing I want to see for you and the last thing that you want to be involved in is allegations of fair housing violations and end up at some HUD hearing or before one of the courts here in Illinois. And here's a good way not to have that happen. If you will follow and your office will follow what we've laid out here under our Fair Housing Compliance Program, I think it'll go a long way to protecting you and your office. So let's kind of review this. First of all, you should have some kind of statement in your policy and procedure manual that you've received, that you have your own copy of, that your broker has you actually sign and agree to, that your office agrees to fair and open communities, and the office will not tolerate and expects you not to tolerate anything to do with inconsistencies and violations of federal fair housing laws. So it shows your commitment as a company to the policy of open and fair housing. Licensee education and training. You get some of this as you do CE classes. You're getting some that you're doing now as far as fair housing. Some companies go so far as to have companies like ours, schools like ours, come in and we'll do a 2 or 3 hour update on fair housing. And then we'll also give all the attendees of that a bit of a little certificate that shows that they've attended that. That's very powerful stuff, because if you ever have to defend yourself in a fair housing case, the fact that you as a company, that fact that you as an individual are seeking education is really important to showing you're desirous not to be involved in fair housing. So do more education and training in your offices for fair housing, even if it's an hour or two every 6 months or so. Consistent documentation means that however you document you're working with customers or clients, do it consistently. Use the same contracts, use the same forms, use the same procedures. Equal service. Know exactly how you're going to handle customers when they walk in the door, and treat everybody the same way. So if the policy is they come in your office and they sit in a conference room and then they're served coffee, do that with everybody. If the policy is they come in your office and they sit at in a waiting area and there you bring them water, then do that. If the policy is they come in your office and sit there and wait for the person that's a person to come and work with them and they take them back to their desk, do that. While you're talking to them at your desk, ask them all the same questions. Be consistent. Don't ask African American individuals questions that you wouldn't ask an Asian American, that you wouldn't ask a Hispanic, that you wouldn't ask the Caucasian Americans. Okay, ask everybody the same questions. Qualify them the same way. Don't limit where your prospects are going to live. Let them limit the choices. Let them decide where they want to be. They make the choices, not you. Use that fair housing logo we talked about before. Use the Federal Fair Housing poster that we talked about before. All of those together, that Fair Housing Compliance Program will be a long way that if you ever are charged with any, first of all, it will keep you from being charged with fair housing violations. And then if you are charged with fair housing violations, I think all of these things are a good defense to show that you really are cooperative and you really are committed to fair housing as an individual licensee as well as an office. Antitrust always is something that we need to be concerned about, both on the federal and state level. On the federal level, antitrust laws that we want to follow are the Sherman Act. The Sherman Act prohibits and discourages, prohibits competition. It discourages monopolies. It discourages the use of monopoly powers. The idea with antitrust acts is that we have an open, competitive marketplace where our customers in the United States and our clients in the United States get the best services at the lowest possible prices. Antitrust violations basically are there to keep our clients and customers from getting the best service at the lowest prices. That's why both on the federal and state level, these are laws that if violated, we can have sanctions against us. The federal laws are administered by the U.S. Department of Justice and the Federal Trade Commission. Our state laws are patterned after the federal laws, and they can subject the brokerage company or individuals to state sanctions as well as those federal sanctions that you might get on a federal level. What are the kinds of antitrust activities you can engage in? The biggest one is setting commissions. So your commission rates cannot be set, should not be set, and should never be discussed between offices. Commission rates are only, and commissions are only a discussion within your office and with your broker. Don't even discuss them with your other agents. Discuss them only with your brokers. You don't discuss them with agents with other companies, and your broker doesn't discuss his commissions with any brokers with other companies. So commissions are only between real estate agents and their brokers, not between agents, and certainly not between offices. It wasn't that long ago when you'd call up a real estate office and someone would say, I'd like to list my property, what do you charge? And the agent would say 7%. And the prospective seller would say, boy, that sounds like too much. I think I'll talk to somebody else. And the agent would say, well, that won't do you any good because we all charge 7%. And the seller might say, you all charge 7%? Yeah, it's a rule from the multiple listing service, or it's a rule, it's a state law, or some nonsense like that. Commission rates are set by each individual office, and they're negotiable with your sellers in every case. But before you tell a seller what the commission rate is going to be, make sure you check with your broker. Boycotts. Boycotts is where a group of offices would boycott an individual office. Perhaps you have an office in your area that's a flat fee broker or a very reduced fee broker. And the other brokerage companies would say, well, we have a way that we'll teach him a lesson and we'll make him fall in line with our pricing structure. What we'll do with that broker is we will boycott his listings. We won't show his listings until he comes around and charges what we all charge. That's a group boycott, illegal, antitrust. Territorial allocations, where a group of brokerage companies might get together and take the territory and allocate the markets to each other. So I'll take the north side of town, you'll take all the properties on the west side of town, somebody else to the east side of town, somebody on the south side of town. So we allocate the territories, and that way we don't have to compete with one another. Illegal, antitrust. Additional risk-related concerns. Whenever you're dealing in a real estate transaction, always refer to the experts. Be careful of what you say. When you say something, you can be held accountable for it. So if there's something about the property that the home inspector came up with, let the home inspector defend it or talk about it. If there's some way to mitigate it, or there's a way that can be cured, let the home inspector or someone else come up with the ways that can be mitigated or handled if there's been a defect. Let the attorneys deal with the legal issues on the properties. Let the lenders deal with the financing issues or the short sale issues. You have to be careful of what you say. Avoid the unauthorized practice of law, which is where in our real estate transactions we deal only with our pre-printed contracts that have little spaces to fill in. We fill in the blanks. Or we can strike things out in these pre-printed contracts. If we add anything to our contracts as real estate brokers and salespeople, we would add other mini contracts, which we might call writers, that have lines that we can fill in or clauses that we can strike out. But we don't write contracts. We don't develop it. We don't put the verbiage in contracts. That is exclusively the domain of real estate attorneys. Take your Chapter 3 Risk Management quiz, grade it, see how well you're doing, review the chapter for anything that you're having difficulty with, or give us a call.